So here's the alleged charges. Money under false pretenses. And then where's the exploitation of the elder one? Boom, 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 boom.
Right here, with the temporarily, that's a permanently deprived Michael. That stands
All right,
for
so
that.
one account of money under false pretenses, and then exploitation of an elder.
And then real quick, because we pulled up these two.
Oh yeah, that's when.
Yeah, this is talking about the penalties for larceny. So since it says exceeds $1,500, it doesn't exceed $1,500.
Yeah, so that was
can't be a felony.
So they were trying to use this to get away out of you saying it's not real money.
Yeah, exactly.
So they're trying to convince you like, oh, since it's not that bad, they're trying to drop it from a felony to a misdemeanor when the principle alone is that you haven't taken any money.
And money, yeah.
All right.
Period. So I still argue that with him too. I'm like, I don't care that you're saying that. I'll still put in the affidavit.
It's already in there. It's already on the record. So we're gonna read now what we sent to combat these charges.
So, affidavit of fact, quo warranto, and information. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent. UCC 1-202. In attempts to ensure that I am dealing with a legally and lawfully competent court with prescribed jurisdiction per Article 3 of the Constitution for the United States of America, I rightfully demand to see the judge's oath of affirmation to support and defend the Constitution in regards to this matter. It has already been declared in the Clearfield Trust Company versus United States case in 1942 that governments descend to the level of a mere private corporation when dealing with suits in regards to private commercial paper, Federal Reserve notes, and securities. To ensure that this is not a commercial court, it must be clearly established for the record that the judge appointed to this case are an Article 3 judge. If in fact they are an Article 3 judge, being so, they have a constitutional obligation to ensure that my constitutionally secured right to due process is not violated and known that they lawfully and legally do not have jurisdiction in this matter. Therefore, it must be thrown out, and any attempts to adjudicate on this matter is unlawful and unconstitutional. Therefore, is an act of treason against not only me, but the Constitution and the American people. As mentioned in the Owens versus City, Stone versus Powell cases, state courts, like federal courts, have a constitutional obligation and are to protect the people from encroachment of their secured pre-existing rights and liberties. Considering it has not been proven that I have obtained any money, as the only lawful money is gold's coin or its silver equivalent, I cannot be charged with obtaining money on false pretenses, as gold has not been in circulation since the Federal Reserve Act of 1913. Governments only have a say in regards to the strict and technical definition of the word money. If I am being charged with obtaining Federal Reserve notes, private commercial paper, then this must be a commercial court to which jurisdiction can only be established if there is a contract on the record that I have abridged or am supposed to have violated, to which the corpus delicti must be present to ensure that he or she is in fact the person who is making claims against me, to which his or her sworn affidavit of those claims must be signed by them and entered into the record. Considering there is not a human being present to ensure and attest to the claims made against me, bearing witness to the said signed affidavit of claim made against me, that in honor and alignment with the 5th and 6th Amendment, which state I have the constitutionally secured right to face my accuser and ensure that I have the right to due process of law, then I demand that the alleged charges of obtaining money on false pretenses be dropped, dismissed, or otherwise acquitted, considering there is no grounds for that charge to held against me as an injured party and contract have not been properly identified. The alleged offense of exploitation of an elder must be dropped as well, considering no lawful or legal money was taken from anyone and the alleged accuser is not present, nor is there a signature of any alleged accusations linking it to a living man or woman. Thus, it is prima facie evidence that these charges are artificial, leading me to the conclusion that this is in fact a commercial court, to which all parties involved except me are co-conspirators and attempt to extort finances from me, thus chargeable under Title 18 U.S. Code subsection 241, conspiracy against rights, and Title 18 U.S. Code subsection 880, receiving the proceeds of extortions et alia. If the injured party is present, then I rightfully demand that Michael Randolph and Phyllis A. Randolph present themselves, properly identify me as the alleged defendant, and make claims to the signed affidavit of claims made against me. If they are not present, nor their sworn affidavit of claim made against me, and or their authorized representative with the signed agreement between the aforementioned alleged injured parties and their agent entered into the record, then these alleged charges must be dropped. There is not one document with Michael Randolph and Phyllis A. Randolph's signatures on them, and that alone stands as prima facie evidence to the violation of my right to due process, as the sworn and signed affidavit of claims made against me, which move the courts must be present and identified for the public record.
And instrument is deemed at law filed at the time it is delivered to the clerk, regardless of whether the instrument is file marked. So that's notice to the agent is notice to the principal. And you know, these are other things. So also more case law. If this is a criminal matter, there must exist an injured party to which I am obligated to make remedy to. If this is a civil matter, there must be an injured party or property, even unto the preponderance of evidence. If this is administrative court, traffic court, as well, there must be injured party as well as defined and established rule of law submitted in Exhibit A. So that Exhibit A is their signed affidavit saying that you injured them.
Mm-hmm.
And then here's the certified mail that she sent it. And then if you want to look it up, is that the case? I can't remember. Fuck, was that the case number?
No, that's just thingy. The other thing, the P2.
Oh yeah, the
thing
P2 whatever
is the case
shit.
thing. Yeah.
I'm not sure if that's on here. Oh yeah, that.
Mm-hmm. That's the case number.
Yep. And then proof that it was sent, certified mail. So on the document, those numbers link up with this stamped by the post office. Boom, 1, 2. Yeah, it's hard to do with one hand. Boom, those numbers match up. And then the receipt from the post office. They didn't want this on the record. It's already on the record though.
There you go.